Good afternoon. I'm Ken Canderas, the Director of the Center for Advocacy, and I'd like to welcome you to this afternoon's presentation. It is one which is a part of our occasional speakers program, speakers brought in to address various issues of trial advocacy and dispute resolution. I would like to turn over the formal responsibility of introducing our distinguished guest today to Professor Ron Smith, who's had the pleasure of working with Mr. Albert Krieger over the last few years on a number of projects, but not the least of which is our very successful John Marshall ABA Criminal Justice National Mock Trial Competition. Professor Smith, please.
Thank you. Imagine, if you will, a serf working in the fields of some feudal society in Europe 400 or 500 years ago. And one day he looks up and he sees the king and the king's retinue pass by. For the rest of his life, that man will tell his family and his friends about the day the king rode by. In 1972 or 73, I had the pleasure of going to a conference where I heard Albert Krieger speak for the first time. And I was like that serf. For the rest of the years that went by, I would tell people about the day I heard Albert Krieger speak. He speaks bluntly, he speaks the truth. He is a lawyer's lawyer. And sometimes I think of the anecdote of apparently an old Caucasus anecdote: if you will speak the truth, you'd better have your saddle on your horse at all times. It's my privilege and my pleasure to introduce Albert Krieger, who is in town in connection with the American Bar Association Criminal Justice Section Council meeting. 2 weeks ago, he was here to be the featured commentator for the ABA John Marshall National Trial Advocacy Competition. Many of you heard him at that time, and that's why you're back. So please, Albert, come up and talk to the students about anything you want.
Thank you very much. I've had two surprises since I walked through that door. The first was meeting one of the members of the Board of Trustees, Mr. Hammond, with whom I just spent a few moments recalling, at least he was recalling and refreshing my recollection, as to a seminar in which I spoke about conspiracies, trying conspiracy cases from the defense viewpoint, and one of my more favorite topics, that is informers and how to deal with them. The second was Professor Smith mentioning an event 22 years ago. It fits in very closely with what has been on my mind since the reality that I would be here today to speak with you clicked into the jumbled mass of incoherencies that lie behind my eyes. I have been indulging in retrospection. I have been thinking of standing before a group of law students, projecting myself into considerations, cares, concerns that I had and still have concerning my number 3 daughter, who is an accomplished felony trial lawyer in the Dade County, that's Miami, Public Defender's Office, and what she went through in law school and in her training. And then in all the years that go back to the time when I raised my hand to become a lawyer. The moment of becoming a lawyer for me is forever in my mind, but not because I became a lawyer, but because it was the day after my oldest child was born. And on June 28th of this year, that will be 45 years ago. And in the 45 years, I have, save once or twice, done nothing else but been a criminal trial defense lawyer. And in those years, I've been exposed to the best in our system, to the worst in our system. I've been exposed to the innocent, to the guilty. I've been exposed to the judges who are paragons, and to the judges who are disruptive and disgraceful within our system. And as a result of those varied experiences, and as a result of having survived until this point, I've engaged in kinds of analysis. One, comparing your life to mine at equivalent stages, thinking of where our country is today, where our world is today, what is your role in the future, and what is my role, if any. And because I started to talk about retrospection, I must think also of what my role may have been. Whatever I have been, whatever I am, whatever I will be, is unimportant, is meaningless, and should be of little moment to you. What is of importance is what role will you assume in the near future? How do you see the world today? How would you like to see the world? So when Professor Smith spoke to me of rights, responsibilities, and retribution, the first question I had was, whose rights? What rights? If rights exist, where do they exist? Is it my right to walk down any street in any city and be free from fear? Is it my right to have the guns in a community swept up by our law enforcement officers so that I will be able to exercise my right to be free from fear? Is it my right to have quarantined from me and mine all those who would violate my privacy, my body, my mind, my sense of individuality? Are those rights? Is it my right to feel safe when the police go into a home to search for guns without benefit of warrant? Is it my right to feel safe, and if so, where is it inscribed, for the police to pick up someone less fortunate than I, and when that person says, "Should I have a lawyer?" have the response be from Mr. Justice Scalia, "We cannot set up a system for idiots. If he wants a lawyer, he should ask for it." Where are our rights? I fear that most of you might say in the Bill of Rights. And then I would politely suggest to you, read them. And think if your answer then is correct. If you read the Bill of Rights, the first 10 amendments, as I do, then you will see that 6 of them are prohibitions or restraints against the exercise of governmental authority, limitations on the power of the government. They are not statements of awarding of right. And yet we find time and again members of the Supreme Court and aspirants to the Supreme Court who say that the only rights a citizen has are those which are enumerated within the Constitution, disregarding the 9th Amendment, which is the Reservation of Rights Amendment, which says that you, the people, are the storehouse of individual right, not the government, and that in this magnificent instrument, the Constitution, you have constructed a means of bringing some order to our society, yet maintain the free interchange as amongst all of us. And you also, in conferring powers on the government, have limited those powers by express wording. You don't have to go far to read what the Chief Justice has to say about that, and certainly not Justice Scalia. And maybe you will find comfort in the words of Justice Blockman when he said in an opinion recently that at last Chief Justice Rehnquist has permitted the public to view his cramped at one point, his constricted at another point, his confining at a third point, view on individual rights. Well, if you start there with a view towards rights, then maybe you will consider your responsibility, and I say this most respectfully, towards those you love, towards those you will love, and towards those yet unborn. I look upon my life and I tell you true, that I have been a failure, a gross, craven failure, because I, who am vocal, who have been in the position to bring to public attention abridgments of individual right, have been unsuccessful in creating a country in which I do not feel that I would have to say that which I say to you today. In effect, I am asking you to do the job my generation failed to do, and I wonder whether my children's generation will be able to, and I'm grossly unsure about my grandchildren. Let me give you some examples while we talk about responsibilities. I am a Jew, and we have remembered the Holocaust in Germany frequently during this past month. I was in Dachau, not as an inmate, but as an American soldier, while the ground still stunk. And within 3 years, after the world knew of the slaughter of 6 million Jews and 3 million others in an organized fashion, the Malaysians and the Indonesians and the Nigerians were killing one another in the same fashion as the Nazis had just a short moment before. That in the years that have gone on, today we have the Tutsis and the Hutus killing each other by the thousands in Rwanda. We have the slaughters in South Africa. We have Bosnia-Herzegovina. We have Israel and the Arabs. We have Ireland, Northern Ireland, that ongoing tragedy. That the world, our generation, our people do not take the responsibility to see that recognized individual rights to live and to let live are permitted. We have failed. Will you? Will you? I look around this audience and I see some signs of hope. Not enough, but some. The signs to which I'm referring are that we have a good mixture of sexes. We don't have a good mixture of races. That without the mixture, we have building antagonisms. That with the building antagonisms, we have the erosion of right. So we have 3 strikes and you're out. We have the federal death penalty. And let me tell you how racism inserts its way into that. With the federal death penalty, you will find within 10 years, and I warrant this, within 10 years, that the death camp they're building in Indiana near Terre Haute will be filled with Native Americans, because those are the ones who are going to fall under the federal death penalty law. And our prisons, with 3 strikes you're out, they are going to be filled to overflowing with primarily blacks. So we say in one breath, we've lost a generation of young black people. And then in the next breath, we say, what is left of them, we will warehouse. You watch TV, and it is a contest, as amongst the various legislators, who is going to propose the more draconian punishment? Who is going to decide what insignificant event, comparatively speaking, can be punished by the most severe sentence? Let the elderly sleep in a cardboard box under the highway. But if you want good food, good care, go commit 3 crimes. And you can live out your days in comparative comfort, that is comparative comfort to a cardboard box, in a jail. But let's not even count up the youth that we will lose. Let me see if I have the figures correct. I may not. I spoke of this about 6-8 months ago at a seminar in Florida. Florida, indulging in, shall we say, giving all people opportunity to be represented, gerrymandered a district. That district is like a snake with a broken back going up the southeastern coast. And as a result, they were able to get elected a black congressman who will do very well and certainly deserves to be in Congress, but should be representing more than just that contorted district. That district was made by the court. Why was it made by the court? It was made by the court because the Florida legislature couldn't get its act together. So they hired lawyers. And they paid the lawyers $1.45 million in fees for a job they couldn't complete and didn't complete. And then went to court $1,450,000 poorer. So the newspaper article that reported this, of course, was gleeful to state how the legislature had wasted the taxpayers' money, and said, with that $1.45 million, think of it, ladies and gentlemen, we could have kept 95 people in jail for a year. Isn't that great? And as a footnote, we learned a day later that that $1.45 million would have paid for a year's education for 2,393 children. There was nothing in my experience of recent memory that has drawn with such stark reality the problems we face today. I say to you, I want to be safe in the streets. I grew up in a town with 800 people in it. 800 people. We knew everybody, everybody knew us. The law was administered by a boot in the rump from the local one of 4 cops. You misbehaved, that's what happened. God forbid he should take you by the scruff of your neck and bring you home and give you to your mother or your father. I did not have a key to the door. No one of us had a key to the door. We didn't know what it was to lock up a door or lock up, if we were so fortunate at that time to have a car. Life was simple. Life was easy. Now I live in a house with a fence and an electric gate, TV monitor, alarm system, and a guard dog. And every waking day, I say to myself, why? Why? What did I do wrong to bring this about? Could I have done something right to prevent its occurring? Or is my lifestyle retribution for my life as a criminal defense lawyer? Has it come full circle? Am I being visited by some of those, in effect, that I have obtained freedom for? Have things that I have done that have brought about the acquittals of felons through myself or others, the retribution? If that is so, if that is so, then I say to you, so be it, and I sneer in the face of the devil. And I turn the race to you. You people here, the lawyers of tomorrow, are those who, if you are honest to the oath that you will take and to the faith that those citizens accused will have when they turn their plight to you, if you are honest to that, then you will do certain things that I hope and pray will result in education of our country and perhaps the world, and maybe in some time too far away to see, there truly will be peace and liberty. And I give you example. It seems to me a long time ago that I said to some people, I don't know whether the case that I'm going to try will result in a conviction or an acquittal. If it's an acquittal, I will celebrate, regardless of the fact of guilt or innocence. If conviction, I will despair and I will grieve. That is because, number one, if you walk into a courtroom to try a case, you are in there to win. There is no second place. There is no well bowled. There is no, it matters not whether you win or lose, it's how you play the game that counts. You are in there to win, but you are also in there for other things. You are in there as a missionary. You are in there so that 12 jurors will walk out of that courtroom saying, now I understand how the system of justice should operate. Now I understand what the presumption of innocence is. Now I understand what proof beyond a reasonable doubt means. Now I understand what it means to have a voice in my battle with the government. Now I know what it means for the government to be held responsible not only for prosecuting the guilty, but for protecting the innocent. And what is more, those jurors will learn the appropriate role of the judicial officer. If I have done that in a case that I try, then I have something to remember about the trial that will give me comfort in the event I do not have an acquittal. But I want my acquittal. I want my acquittal, but not at the price of or the cost of my integrity or the integrity of the judicial system. Regardless of how much a competitor and how much I want to win, there is, in truth, little lasting satisfaction from an acquittal obtained because the prosecution was inept, overreaching, or stupid. Or the acquittal was obtained because of a rejection of misbehavior by the trial judge. I won't bring up misdeeds or misdoing by the defense lawyer because that should never, ever, ever occur. If you can't walk head high, you can't represent a citizen accused of crime. I have, as I told you, been in the worst cases in the history of the last 50 years, and in 45 years never cited for contempt. Eyeball to eyeball with the toughest judges and the toughest prosecutors, but always as a professional. Always with respect for the system and what the system represents, and always with understanding of and support for my client. And there have been tough ones. Can you have an effect? Yes, you can have an effect. And I'm going to impose upon the patience of some of you who have heard me relate this story before. But I will put it into context, and I apologize to those who have heard it. (1973). The Sioux Nation erupts in a revolution that became known as Wounded Knee. How did it come about? Politically, the American Indian movement, for whatever its defined purposes were, and I don't pretend to know, brought about what was called an uprising at the trading post of Wounded Knee outside of Rapid City on the Rosebud Reservation in South Dakota. Trading post was taken over, was sacked, and removed from the trading post were a variety of its contents, things going from typewriters, one or two of them, to blankets, to food. They were all taken into the little church next door to the trading post, and from there distributed to the Native Americans who lived on the reservation in shacks and hovels on dirt floors, but they had electricity. Our government had done everything it should, gave them electricity. The government responded by sending in the troops, FBI agents, United States Marshals, and a siege began. Oh, there were huge issues to be tested here. After all, there was a little post office in the trading post. And the whole postal system of the United States was going to come a cropper because, after all, it was no longer functioning at Wounded Knee. So the troops come in, the siege goes on. Eventually, the siege terminates, and the government brings 143 separate indictments against these terrible people. They all had, oh my gosh, names that put fear in your hearts. Joan, man kills underwater. Francis, killer. Ralph, crazy bear. Traditional names, which might indicate to you how far removed they were from the mainstream of Chicago, New York, Philadelphia, or what have you. Well, under the Assimilated Crimes Act, they were all prosecuted for burglaries, receiving stolen property, and similar crimes. The National Association of Criminal Defense Lawyers, which then was at the low point of its membership, it probably had a grand total of 50 active members and maybe 200 around the country paying dues, by mistake more than likely, was in its annual meeting at Dallas. And we received a telegram. And the telegram said there are these 143 indictments, and there are no lawyers in South Dakota who will undertake the defense of these people. Chew on that for a second, if you might. Persons within a community in the United States charged with crime to go totally unrepresented. Without being too patriarchal, you have grown up under the Gideon case and under Argersinger against Hamlin. So since 1963, it is your understanding that all persons are entitled first to counsel in felony cases, and since Argersinger in misdemeanor cases as well. Well, if you go back to my day, that wasn't so, because it was only since Powell against Alabama in the mid-30s when the Supreme Court said that in a capital case you're entitled to counsel. So the Sixth Amendment and all its magnificent safeguards was really an empty letter in many ways until an activist Supreme Court took it, first for the horror that was Scottsboro, and secondly for may he be in the most golden chair in heaven for Chief Justice Warren's court. That's when you can start to count your rights. So here, no lawyers. Not a lawyer in the state will undertake their defense. We sent one of our members up there to see if it were true. And lo and behold, it was true. So roughly 30 of us volunteered. And come the winter of '74, it was my misfortune to wind up in Sioux Falls, South Dakota, trying the first of this series of cases. I thought I would be there week, 2 weeks. I was still there in July. Still there in July. But what's the point of that? Not that I spent that part of my life trying that case. Far from it. Number one, that there were lawyers such as you will be, who were willing to come from varying points in the country in order to represent people who were charged with crime by an overreaching government, and to represent people who really weren't too happy to be represented by somebody with white skin and blue eyes. If anything, persons such as myself fitted the stereotype of the ones who had committed genocide upon those people. And there were those still alive at that time who remembered the death of Bigfoot in the snow, that last slaughter of the Sioux. Well, the main defense team for 4 defendants consisted of a Jew from New York, a Catholic from Maryland, a Protestant from Indiana, and I don't know what from San Jose, California. And we proceeded to try this case. The judge, Lincoln, Nebraska, Nixon appointee, had handled insurance defense work his professional career, and specially assigned to take this case. Then Judge Warren K. Erbaum from the District of Nebraska, presently Chief Justice of that district, Chief Judge. Let me put this in context. First day of trial, show up, lawyers sitting around the table. Albert, we were waiting for you. Why? I'm sorry I'm late, but what's the big deal here? We got a problem. What's the problem? The defendants will not rise for the judge. Oh, that's a big deal. Oh, boy. So what are we going to do? They said, well, we weren't really sure. I said, come on. We go back into chambers. Your Honor, it's a pleasure to meet you, so forth. We have a slight problem, Your Honor. He says, what is that? He says, well, the defendants will not rise when you come into the courtroom because they think that would be acknowledging the sovereignty of the United States government, and because they believe that they are an independent and sovereign nation pursuant to the Treaty of 1867, they are exercising their sovereign and independent rights. That's heavy duty. You know, that's real heavy duty. Bothers me no end because that means I'm going to have to read the Treaty of 1867. Because as a criminal defense lawyer, you know, I answered ready, but I wasn't prepared. So, Judge Erbaum looks, turns to his bailiff, and says, delete, please rise from the proclamation. Can we go ahead now with the trial? Oh, yes, Your Honor. We go out. We start the case. Case goes. Defendants ignore the judge, ignore the niceties of the courtroom, sit there politely. Of course, when the judge comes out, all the white people rise. Judge goes out, all the white people rise. We're following the appropriate decorum. About 6 weeks go by. And in the 6 weeks, we had developed evidence such as the fact that the traders were running a Shylock organization amongst these poor Native Americans, whereby when they would get they would lend $1 for 75 cents interest a week. Now, I was recently from New York. Even on the New York docks, they didn't have the nerve to do that. And what's more, they were collecting. How they were collecting was because they were also postmaster and postmistress, and when the relief or aid to dependent checks would come in, they would cash the checks, take the interest out, and let them have a few cents so that the debt would keep going and going and going. And when the poor Native American died, the biggest claim on the estate for the land was the trader. All of this in absolute violation of the CFRs. Specific laws against the destruction of the religion by the selling of artifacts. Walk into the trading post, every conceivable religious artifact had a price on it. We demonstrated those things and other equally outrageous violations of law to the court, and then brought a motion to dismiss for outrageous misconduct by the United States government, vigorously opposed by the special prosecutors, who were professional people. They discharged their duties, free, in my opinion, free from bias, and as lawyers should. We had a fight for everything. They had a fight for everything. Of course, they didn't indict the FBI agent, special agent in charge of Minnesota, North Dakota, and South Dakota, who broke down at the end of my examination confessing to be a perjurer. But that, maybe I'm being picky. We bring this motion, outrageous misconduct. And it was like on a Thursday afternoon. Judge Erbaum comes onto the bench and rules on the motion. And he begins it. I remember so clearly. There are things that are etched in one's mind. He says, I tell you true, I took an oath that I must support the law, and that to render a decision, I must look to the law and not my heart. My heart breaks at what I have to say, but say it I must. I deny your motion, and we will proceed with the trial. And he walked off the bench. We thought we had a winner. We were disappointed. Court recessed to the following Monday. Parallel with these events, there was a state case being prosecuted in the Minnehaha County Courthouse, downtown Sioux Falls, South Dakota, which arose from some other incident that misbehaving Sioux had brought about. And I think these were really misbehaving. I think it was a drunk brawl. I don't remember the incident. But they're going to trial in front of a jurist whose name was most appropriate for his intellectual abilities, personality, and judicial demeanor, Judge Bottom. Judge Bottom comes out on, this is the sequence of events, on Wednesday, begin the trial. The three defendants don't rise. Well, he stops in mid-stride, looks and says to the lawyers, "Robing room." They come into the robing room. He says, "I'm a judge. I come out, everybody rises. You tell your clients that. Recess until tomorrow. Teach them." Following day, comes out. They don't rise. Tells the lawyers right from the bench, tomorrow, they will rise, or else I'm holding you in contempt. Now, this is typical judicial brilliance. You run into this from time to time. You won't find it in the books, but it's a functioning fact. I think when they take their oath, they also take an oath, I'm going to do something stupid sometime. It's going to hold the lawyers in contempt. Next day, well, these lawyers had guts. They showed up. Nobody rises. Puts it over to Monday and says there'll be an end to this on Monday. Monday is the same day that we are returning to court after the decision denying our motion to dismiss. We come in, when the persons come into the state court, 7 Lutheran ministers walk out of the robing room. They had heard about this situation and sought to prevail upon Judge Bottom to alleviate this situation, do what Judge Erbaum did. His trial is proceeding. It seems rational, seems reasonable, and justice apparently is being done. He threw the ministers out, walked out. The Indians didn't rise, told the deputies, make them rise. And a riot ensued. In an American courtroom in the United States, the deputies beat 3 defendants senseless, including taking the eye out of one. When the screams reached the street, a riot occurred, and horror of horrors, something like $60,000 worth of damage was done to the Minnehaha County Courthouse. That evening, we are at the Town and Country Motel, this lovely place where we were staying, watching the news, and the good citizens of Rapid City who were there at the bar said the following: "Give me a machine gun, I'll take care of all of them." You can fill in the rest of the words. Custer was right. Every racist epithet that you could think of was employed as to what should be done to the few remaining and surviving Sioux. Well, needless to say, being a lawyer of substantial experience by that time, I was not going to stand on the bar and lecture this group on civil rights. Nor was I about to identify myself as one of the lawyers. The following morning, oh, I will never forget this. The following morning, get into court, gray, snowy day. Because of the riot at the Minnehaha County Courthouse, the FBI and the marshals and whatever stormtroopers were available were in the federal courthouse. Obviously, the feeling was that something was going to break loose. They had better intelligence than we did. Sitting there waiting for 9 o'clock to roll around, and we hear a disturbance. This courtroom was on the 2nd floor. It sat probably 200 people. It was a huge room, one of these old vaulted ceilings rooms. we hear the tramping of feet and we hear some shouting. And the big double doors over on left side as I face it open. And in come the Sioux Braves. On this cold, snowy, wintry day, they come in with the deerskin, porcupine quilled vests, rabbit fur in their hairs, bare arms, each one looking like an accomplished weightlifter. They came in literally by the hundred. There was not an empty seat in that courtroom. I turned to my client, with whom I had had very few words. And her expressions to me were always polite and non-communicative, and Mr. Krieger this and Mr. Krieger that. Generally responses to my direct questions. And I said to her, oh, in truth, let me tell you, I thought I was dead. Fortunately, I had no fear of being scalped. I said, Lorelei, what's going on? And she said to me, Albert, don't worry. And that's all she said. And that's all we could learn from the defendants at counsel table. The just under 200 Sioux Braves sat there like this. The courtroom was ringed by marshals and FBI agents, and it was the only time, save as an exhibit, that I've seen long guns in a courtroom. If a shooting would have broken out, I'm sure in the crossfire, everybody would have been killed. Three knocks on the door, and from that door over there, out comes Judge Erbaum. Comes, takes about 2 steps, and the Indians rise. He stops. He turns to them. We who had risen automatically had heard this behind us and turned in astonishment at what had occurred, and turned back to Judge Erbaum and in truth saw a glistening in his eyes, and he turned and walked back. They sat down. We at counsel table, 4 tough, tried, experienced criminal defense lawyers cried openly, because we knew that for that moment we had built a bridge across races, across genocide, to people who had the heel of the oppressor ground into the back of their neck. And if we could do it, then you can do it, and others can do it. And that which exists that is of hate and degradation in our country need not exist. That was what flashed through our minds in that moment. And perhaps 90 seconds later, the door opened again, and Judge Erbaum came out, and they rose. And he walked up to the bench, and he couldn't say, please sit. He was so moved by the moment that he could just sit there and try to gain enough control over himself to conduct that court with the decorum that it deserved. And for that day, ladies and gentlemen, for that day, every time that judge rose to leave or to come, the Sioux rose in respect for a man of honor, of truth, and in respect for the system that had demonstrated that people of integrity, of good spirit, of honesty, of devotion can bring peace to disruptive societies. Well, ladies and gentlemen, there's a tale to the story. The following day, they went about whatever they were doing and did not appear again. And some months later, Judge Erbaum acquitted the defendants. That afternoon, again at the glorious Town and Country Motel, the chief prosecutor came to me and said, "Albert, I have a deal for you." So what's the deal, Joe? He says, you get pleas from 4 defendants, he identified who they were, and we will dismiss the remaining 140, 30 some odd indictments. He said, if that's the deal, let's lay it out before the judge. Next morning, we go to see Judge Erbaum. Your Honor, this may assist your scheduling. We have a way to get rid of all of these cases. Listens to it, and this is the only thing that I have to say about Judge Erbaum which could even be misconstrued as being something unflattering to him. He said, Albert, I want you to stay until the deal is done. Mind you, this is the middle of June. I've been there since February. My respect, admiration, and love for that man was such that I begrudgingly agreed. United States Attorney was at the meeting. Bill Clayton agreed to the terms and conditions of our entry of these 4 pleas, including which, at the allocution for sentence, the government would remain mute, except in order to respond to, quote, blatant perjury in our sentencing allocutions. Otherwise, everything was fine. Well, needless to say, to find those 4 defendants and get their consent and approval, you had to go find who was smoking or chewing peyote and who was in what sweat lodge. They weren't exactly the most accessible. And it took about 10 days. And all agreed, and we came back, met with the judge, at which time the United States Attorney said, I have to get approval from Washington. At which moment, I went ballistic, as you could imagine. Judge Erbaum permitted of himself one expletive. It was the classical, white, forked-tongue treatment of a commitment to the Sioux. We had no choices. We had to wait and see what would happen. I'll tell you what happened. About 2 weeks later, I was back home, thank God, in Florida, when I heard on the radio that the Sioux had withdrawn an offer to plead. It took me about 6 hours to get to somebody who was in a position to talk about it and learned that I was the only person who had authority to speak on their behalf, and I had not spoken. The door to the Department of Justice was sealed shut. I could not get in. I then spoke with Judge Erbaum, reporting to him, and he smiled and said, well, we will proceed with some of these cases. And 2 days later, an order came down dismissing 60 some odd, and then motions in limine were granted that took care of another 60. So the mills of the gods ground exceedingly fine. But the bridge that was built was ruptured. And we were put back insofar as the relationship between the Sioux and oppressed people and our government was concerned, to a point as if that which we had done had never occurred. Now, what's my point here? My point in telling you this was not to tell you of an experience that I had to fill up some time on a commitment to speak to you, but rather to use that as an illustration, if I might, of what is, oh, I will be so presumptuous as to say this, my message to you. There is nothing that occurred in that trial and that experience that cannot be repeated time and again by you as trial lawyers, be the cases civil or criminal, if you are as proficient and as capable and as ethical and as responsible as a human can be. That you will study, you will humble yourself and recognize your frailties and your shortcomings, and also recognize that you would not be here unless you had qualities that distinguish you from others, and utilize those self-same qualities to make yourself the best. As much as I dislike the military, they are right on when the Army says, be the best you can be. If you are the best you can be, you multiplied by 12 time and again, will be sending people home to teach their children about the magnificence of the individual rights that we seek to preserve on a daily basis in our courts. Because our courts are the only place, they are the last refuge of freedom. And they remain that refuge so long as you are proficient and honorable. What a glory it is to know that, number one, a fellow comes to you and says, my life, my fortune, my liberty, how I appear to my children, how I appear to my loved one, is in your hands. Will you discharge your responsibility of being my voice in court? Oh, it can break your back if you think about it. If you accept that responsibility on a one-on-one basis, then you will prevail. if you become case-hardened, if you no longer care, then all that we have fought for has been lost. And truly, our lives and our efforts have been failures. I think I have spoken to you in relatively morose terms in some views of the future, except for me that it was a convenient setting for that which I wish to say. But I have faith. I have faith in the youth of America, and I'm no politician. I see young lawyers who are years ahead of where I thought I was when I had 10 years or 15 years of experience on them. When I speak with the young lawyers, I find people of, such quick response and such bubbling intelligence and such enthusiasm. Something I knew very little about. I know that you would not be here, both at John Marshall, and have taken the time from your busy day to hear me, unless your heart was true and your heart was good. And for that, I bow to you. Thank you.
We'll let them ask a couple of questions.
Thank you very much. Thank you indeed. Thank you. How nice.
We'd like to take a couple of questions at this time, and there will be some refreshments shortly. Let me see if I can identify a hand here. All right. Yes, sir.
When are you coming back to speak again?
The question is, when are you coming back to speak again?
Next time you invite me.
See me. We'll work something out. Another question. Yes, please.
What's your view on the recent crime bill being passed on the death penalty and the desire to make it race neutral?
The
How
question
can
is,
it be race neutral? It can't be race neutral. The very construction of the crime bill, the application of our systems of law enforcement are not race neutral. So they can pass bills from now till doomsday, and it's not going to come out race neutral. We have a very serious problem within our cities today that has to be recognized as, in many respects, based upon race. I tell you something that I don't know, but I hope that if I were a young black, that I would have the vigor to resist what is going on today, to be an activist, as many of them are now. I don't know if I have that, but I do know that those activists are well grounded in their complaints. We need education. We need reinstitution of a family unit that can only come about through jobs, education, and helping people come out of the hole in which we put them. We can't ignore it. Every time you go to Washington, D.C., the most revolting thing that you can see in the world are the monuments, the Capitol, Go into some of the public buildings, the magnificent offices they give themselves. And you walk along the streets of Washington and you see things which are reminiscent of third world countries. How does that exist at one and the same time and not be race-oriented? Would the same conditions exist in Washington, D.C. if the poor, if the ghetto consisted of white people? I tell you no. That what we have done is conveniently, let our reliefs be the product of race orientation. I don't think that we would sit around and let the Serbs massacre Catholics. But they can do it to Muslims. And if what's going on in Rwanda today were going on in a Middle European country, oh my God, the Marines would have been there. It would have been Delta Force by now. No, race is there. And the sooner we recognize it, and the sooner everybody, black, white, get together and say, yes, we have a problem here that is going to be handled only by a reconstruction from the very ground, then we'll get some relief of the pressures from within our cities.
One more question, if I may. Way in back, the lady with the red dress, blouse rather. Are there any tough questions here?
Oh, you know, that's a wonderful question. That's a wonderful question. And I think it feeds in to partially a response to the question before. According to a report that I read, 52% of the American people not only approve of the caning of Michael Fay, but think that it would be a wonderful thing to institute in the United States. I hope that we have progressed sufficiently along the evolutionary scale that we would reject that out of hand. But that, too, is something which is being gauged on racist lines. Number one, they've been caning in Singapore for years. So long as it was an Asian who was being caned, nobody cared. One white American is subject to being caned, and we're ready to send the Marines in. And then all of my nice white neighbors think that this is the way they're going to be safe in the streets, is by caning the young black. Let's say it the way it is. Well, I would hope and pray. You know, my idea of a conditioned precedent to being a judge is that you should spend a year doing hard time in jail. Then you know what you're doing when you say 6 years, 7 years, 2 years, 15 years. Those who want caning should see the results of whipping. I have no idea how anybody who gets 6 lashes with that type of cane can ever walk again. Those gluteal muscles have to be destroyed by the 3rd blow. It is brutality beyond... I can't even begin to address it. Death penalty. If I were attacked, if a loved one of mine were attacked, I'd kill. No question about that. But an individual, one-on-one, killing, that's the nature of the beast. For an organized government to kill is a descent into bestiality. And how, I can't even begin to justify the death penalty. Rawlings, the serial killer, was just given the death penalty in Florida. Hey, if he ever came near me, I think I'd want to kill him. Absolutely. But if I certainly hope I'm not called on to have to file an amicus brief or argue on his behalf someplace, but I would. I don't believe in it at all, ever. I hope that's something of an answer to your question.
I want to thank Albert Krieger and all of you for being here this afternoon. Before he leaves, I want to present Albert with the seal of the John Marshall Law School,
great.
which will have a plate attached to it memorializing his coming here today.
Thank you very much.
I think it was a year or two ago, we were in Barcelona. No, it was Madrid.
Madrid.
And he was present when I gave one of these seals to the dean of the Madrid Bar Association. Albert had already received one of the small cubes which contains a miniature copy of the trial advocacy book, which we send out to all the law schools that participate in our annual competition. He had received one of these as a featured commentator last year. And he looked at the seal that I gave the dean of the Bar Association. Albert said, "This one's metal, I only got paper." So I'm glad now you've got one as good as the dean of the Madrid Bar Association has. Thank you so much for coming to us, Albert. There are some
Thanks again.
refreshments in the next room.